Today's program, Managing the Claims Process, is intended to give you a sense of what the claims process looks like. For most design firms, a claim is thankfully a rare event, and this program is intended to give you an understanding of what the claims process looks like, how disputes are resolved in the professional liability arena, and steps you can take in your practice that will make your life easier if there is a claim. I want to introduce our speaker for the day, Nick Klopuzinski. Nick is a director in the Design Professional Liability Specialty Program at CNA. Following his years as a practicing trial attorney in Chicago, defending professionals and product designers and manufacturers, as well as gaining experience in the insurance industry across multiple claim and risk management functions, both nationally and multinationally. Nick leads a team of talented and experienced claim professionals focused on partnering with stakeholders to positively impact and obtain results, create solutions, solidify relationships, and build value for CNA's customers. Nick, thank you for joining us today. And if you will, why don't you start it off today by giving us a high-level view of how you see the claims process and just give us an introduction of what your thought process is.
I will. Thanks, Nahom. Appreciate the opportunity to talk. And you know, this discussion, this topic today is one of my favorites to speak about. You know, it's effectively what is the claim process. It's an opportunity, I think, to shine light on an area that people are sometimes not familiar with, and it's a chance to have a real impact, a positive impact on everyone's knowledge, and that can influence business decisions. And so the question becomes like, why are you here today? And of course, we get some continuing education credits, and we want to gain some insight and knowledge. And we may be here because we have very little or no experience with the claims process, and that's a good thing, presumably. But it's also good to identify what you don't know and then immerse yourself in what you don't know to help define processes, to help things work better in case you do have a claim. And you may also be here because you have had a claim, or you've had to rely on your insurance policy because somebody made a claim against you, or you had to report a pre-claim. And presumably that's a good thing too, because you identified a situation where you needed to report something to your carrier and you did it. And so now you want to refine your skills and learn a little bit more about the situation in case it presents itself again. So I start off usually with sort of a highlight of what the claims process looks like and how it could feel to somebody who may have little experience or no experience in the claims process. And I put a picture up there just sort of give you an insight into what this could look like, right? So I want you to imagine you're standing on this ledge, you're on this mountain, you're looking down this ski run. The snow is pure and it's white. The sun is shining, it's bright. You got a blue tint because of your ski goggles. And the air is crisp and clean, and it feels dry and fresh as it goes in and out of your lungs. You aren't cold, but you're quite comfortable with a base layer of silk and your ski pants and cozy fleece jacket. Your windproof shell and gloves and helmet feel like a hug wrapped around you, and you hear nothing. It's just silence. It's only the rhythmic sound of your breath, inhaling and exhaling. And you move your legs back and forth, and your feet and skis slide with ease. They're slick. You just put a fresh coat of wax on that morning, and it really did the job with the new layer of powder received overnight. Your poles and your arms feel light and nimble. And you look down the mountain and it's steep, but you're confident. Even though you haven't yet skied this run, you've skied others, you're nervously comfortable. You know the steepness of the slope and how it'll feel. You know how your body's gonna react to your adrenaline and how your legs move to maintain your speed and control and how your edges feel when they grip and when they skid. And you know how it feels to fall. It's happened to you before. You've studied the maps, you've talked to your friends, you've researched chat groups on the internet. You've been here before, even though you haven't been here at all. And you're not alone. There's others standing right there with you, others that are looking down the same mountainside waiting for somebody to bravely drop in. Some locals don't hesitate, they've been there before. They know the territory, they know the terrain, they know their line. They've gotten to the bottom without falling, and they've fallen as well. They know their run and they know their skills. And everyone else has just paused at the top and they look at your direction and they stare at you and they wait for you to make a move. And your adrenaline starts pumping harder as you get ready to drop in, and your breath becomes shallower and more rapid. And you feel the heat course through your veins. You feel anticipation, and you take one more deep breath and lean forward, and there's no backing out now. So as you look down this mountain, there's certainties that you know are going to come, right? You've got trees planted firmly in the mountain. You've got cliffs and boulders you know you need to avoid, and you've got jumps that present opportunities for further fun. And there's also uncertainties that you don't know for sure will happen, such as other skiers flying past you or someone falling in front of you or hidden patches of ice. I'd say project management and claims and pre-claims, either in litigation or not, present the same type of analysis, inquire the same sort of defense, offense, risk, reward, agility, anticipation, anticipatory necessity. You know, when you're beginning a project, that certainties are going to exist. You know who's involved, the type of project that you're involved in, the scope in your project, presumably. And you also know at the beginning of a project that uncertainties exist, whether another project participant completes their scope, the quality of others' work, unforeseen site conditions, or a particularly disgruntled code inspector having a particularly bad day. And the way that we make uncertainties more certain is to learn and gain experience and to talk to people. And that's what we're here to do today. So our objective is to give you a map down the run of this mountain, showing you various lines that exist, identifying the locations of trees and cliffs and boulders, and attempting to bring a little anticipated certainty to often an uncertain claim landscape. So we can begin. Nahom, if you want to go to the next slide.
Thank you, Nick. That was a great picture to kind of lay the groundwork for what we're about to do. So tell us, what is a claim?
Yeah, claim, as it's defined in your policy, will be a defined term. It's going to be a demand for money or services that names the insured and alleges a wrongful act or pollution incident. And there's a couple of things that are listed in this definition that are important, right? So it could be a demand for money or services. Money is simple. You owe me money. It could be in writing. It could be orally. A demand for services can be a little bit nuanced, right? I need you to fix this. I need you to respond to that. Write this letter for this particular, to this contractor, telling him to do something. So it can be a demand for money or services is the first part of this. Then the second part is naming the insured. And what does that mean? The insured is a defined term in the policy. It's broad in general. It includes employees and partners and officers and directors, all acting within their scope of your business, the named insured. And the insured also means the named insured on the policy declarations, which is typically your business, and any additional named insured that could be added by endorsement. And then the final sort of piece of this puzzle is alleging a wrongful act or pollution incident. We'll focus on wrongful act because we're in practice policy territory, but it's a defined term and it is encompassed by two parts. One is the actual definition of wrongful act, and the second is a definition within a definition, and that's of professional services. So wrongful act means an act, error, or omission that causes liability in the performance of professional services for others by the insured or by any person or entity, including joint ventures, for which the insured is liable. And professional services is defined as those services that the insured or any person or entity, including joint ventures for whom the insured is liable, performs for others on behalf of the named insured and the insured's practice as an architect, engineer, interior designer, land surveyor, lead green building program consultant, landscape architect, construction manager, scientist, or technical consultant. So these definitions are broad, and they're purposefully broad. And they are broad in order to encompass your professional work that you do on projects. So jumping into some examples, right? Does a claim need to be a lawsuit? No, doesn't say it. Doesn't say that a claim has to be in litigation. Does a claim need to be a formal written letter? No, there's no requirement that the claim needs to be in writing. So can it be an email? It can be an email. Can it be an oral demand or a notice? Yes, it can be. Can it be asserted primarily against a subconsultant, but naming you or going through you? Yes, it can, because it's for services that you're responsible for or that you are liable for from others. So as an example, right, let's assume you're walking a project with an owner, and the owner is griping about a contractor who isn't keeping on project schedule. And the owner then stops and looks at you and says, you know what the contractor said? He said, well, I can't keep the schedule because of the changes that are occurring with the site plan. And the owner turns and keeps walking. And then he says, while he's walking, I don't care whose fault it is. Could be the contractors, could be the site planners, could be design. I just don't care. I just want this project to be moving forward and you guys to figure out and fix it. Does this rise to the level of a claim? So let's walk through it, right? A demand for money or services. Was there a demand for money or services? And the answer is there could be both here. Did they name the insured? And the answer is yes. You're standing there listening to it. He's blamed design. And is there alleging a wrongful act? And the answer is yes, site planning or design, whether you did it or a sub did it. And so that very well could rise to the level of a claim.
Great analogy, Nick. So let me ask the question then. Let's say that the client says, hey, you have an obligation to re-perform services that are found to have omissions in them. And that's all they're saying is fix this issue on this construction document. And you have that obligation in your contract to re-perform services. Is that a claim?
It very well could be. It depends on the circumstances surrounding, the holistic or, the continuum of what that request looks like. But even if it doesn't rise to the level of the claim, the policy does provide in those circumstances where if it sort of feels like your spidey sensors are going off, it feels like it could be a claim and you just don't know or you need some guidance, the policy does provide for reporting of circumstances, which is something, it's defined as an event reported during the policy term that you reasonably expect a claim could be made. And so it's sort of a catch-all, right? If something feels off and you could expect a claim could be made and it just feels like it could be, you can report it to us and we would at that point determine how we can help.
Okay. So let me ask another question. Let's say there's that ongoing dispute between a contractor and an owner, and the owner sends you a request asking that you turn over documents pertaining to the project. How would you handle that? An explicit issue hasn't been made about money or services, but there is an ongoing dispute. Where would you see that type of issue falling?
Yeah, it's a classic example, I would say, of what a pre-claim probably looks like, what a notice of circumstance looks like, where somebody is asking for your records that you wouldn't need to produce in the typical course of doing business, right? So it's there's a dispute out there, somebody is disagreeing with somebody else, and people start asking for your documents, and it could be innocuous, it might not be something that rises to the level of anything in the future, but at the same token, if there's a dispute already happening, who's going to start blaming other people? And so yes, that to me would be something that would rise to the level of a circumstance that would have my spidey senses going off.
Okay. So in terms of costs, who's responsible for the costs of handling the circumstance? Does it come out of your deductible? Could you explain that?
I did not. So that's a benefit that we encourage reporting of circumstances. We like to get involved early to help people navigate through claims, but also situations that could lead to a claim. And so our policy does not apply to circumstance expenses, meaning that your limit will not be eroded by anything that we choose to spend in legal assistance or costs to help manage a circumstance.
Okay. And then the last question I have is, okay, we've reported a circumstance. At what point does that then become a claim, whereby there are obligations such as deductibles and costs? When does that become from a circumstance to a claim? What do you need to see?
So we would be on the lookout for when the definition of a claim is met, meaning a demand for money or services, naming the insured and alleging a wrongful act. That can happen in the context of working through a pre-claim notice of circumstance where somebody comes and says, well, I do think you're involved and I want you to participate in a mediation. And it can evolve where we have determined as a group that we want to be proactive and effectively shortcut the claim and go in and try to resolve something. But typically what you will find is we were handling a notice of circumstance and somebody then makes a demand for money or services against us. Either the service is being attend to this, help fix that, or we want some money from you, and what are you going to do?
Okay. All right, let's go on to the next slide then. So, what are your duties if there's a claim? What do you need to do as an insured?
Yeah, this is important, right? Because we want to make sure that you get what situation you're dealing with in the right hands. And it's good to remember this before it happens, right? So that you have your playbook ready to go if and when somebody comes to you and says, you know, we want something, and they put a deadline on it, right? So the first thing is to get it to your broker. There are great resources. They will have information, they'll have connections, they'll have, you know, the ability to communicate with all of us, and they're on your side and present as a real ally in the process. As for the technical side of it, it's outlined in the policy that we provide you, and it's good to sort of look in the conditions portion of the policy for how you report a claim or a pre-claim, because there's certain information that's required to be provided, and it's just easy to provide it up front. So it's good to get it to your broker. They will help identify what information is necessary for reporting. They get it in timely and provide that information. It's going to go, once it's reported, it'll go into a system where it's going to be set up and assigned out to one of our claim professionals. Typically, if you've worked with somebody in the past and there's a good relationship there, we try to match that in the future. But sometimes not. If somebody's on vacation or out, it might go to somebody else. And so it really, that email address, designclaims.us@victorinsurance.com, starts that process to get it assigned out. Once the information that you send in there can vary, and it depends on whether it's a pre-claim or a claim, right? So if it's a pre-claim, we like to know what happened and what professional services or activities you were performing, the nature of any possible injury or damages, and how and when you were first brought aware of the circumstance. It's just a narrative, right? We just want to know what is making you, in your mind, think I need to report this because it seems like a circumstance or I'm nervous about it, right? And it could be something as simple as I received a subpoena on X date. Or you could be on the project site and the contractor and the owner are starting to beef with each other, and it's making your job really, really hard, and you think you're going to get pulled into it. So you can provide those narratives. The one thing we do ask is that you don't agree to anything, you don't make any payments, you don't assume any obligations, and you don't incur any expense without written approval from us. If it's a claim, it becomes a little bit more diligent, I will say, because it's important to have all the information for the claim in order to move quickly from our perspective, right? So we want prompt notification. We want the name and addresses of the claimant so that we can reach out to them if we decide as a team that's the right thing to do. We want immediate forwarding of any complaints or legal proceedings, documents that you've received with the claim, if it's in writing. And then we want to make sure that we understand the consent and cooperation and the deductible provisions within the policy, assuming a claim is made. And then, of course, we refuse to make any payment, admit any liability, or assume any obligation without CNA's written approval.
Okay, so we will cover that in a little more detail later, but let's move on to some things that often come up that we often get questions about, such as there's a reservation of rights letter. What is that, and why would a firm get such a letter? If you could explain what that looks like.
Yeah, I love the opportunity to talk this through because it really sort of puts some light into what these things actually are. So the policy outlines what is covered and what is not through the insuring agreement, and the exclusions and conditions and provisions, limitations. It's a lot of words in the policy, but it effectively says what's covered and what can't be covered. Claimants can allege whatever they want to allege in their claims, and many times those things don't present any coverage issues, but sometimes they do, right? So when a claim is made, we need to evaluate what's being asserted to ensure, one, that the policy does provide coverage for it, and two, whether or not that's going to be a full coverage or not. And so if the policy doesn't provide coverage for it, there's something called a disclaimer, right? Maybe a previous carrier that you were with had the claim or notice of circumstances, and it should be under theirs. Well, that would be a reason why your CNA policy may not cover it, right? So that would be a disclaimer. And if there's ever questions about what's being asserted and we don't know the answer to it, that's when we get into something called a reservation of rights, where we just highlight for you early on what could create a potential for a coverage issue down the road, and we send something to let you know that that could exist. The reason why is because we want to be, the law requires, the policy requires, and we require of ourselves that we're open and we communicate openly about what the coverage issues are and what the policy can or can't do. And in the case of a reservation, a full defense will still be provided, right? So it's not like we're saying you don't get a defense. All it's saying is that we have questions about where the loss payment could be at the end of the day. So I think that's a good thing. The costs of a litigation or a claim can typically override any indemnity that's made. And so, having a defense is a really important thing. We want to always make sure before you're receiving these letters that our standard is that we're calling you, talking with your broker to make sure you guys are aware that A, it's coming, and B, answering any questions so you understand the why behind it. So that's a little bit about a reservation of rights. Hopefully it does provide a little bit of light, but certainly if you were to receive one, feel free to pick up the phone and talk it through with us.
Okay. And then, of course, then the issue of defense attorney. If you could explain, how does CNA go about selecting defense attorneys? What your thought process is in that regard, because I think that's very important for.
Yeah, no, that's the second question that comes up is, I need an attorney. How does it happen, right? So if it's a pre-claim, it's a voluntary obligation that CNA assumes, and we typically want to work with people who have experience in managing through pre-claims. But I will say, CNA is one of the oldest, if not the oldest, specialty insurance carrier in the nation. It's founded in 1897. Us and Victor have a long established, probably the longest established A&E specialty program in the market, close to 70 years. And we have relationships with attorneys that extend years and over multiple product lines with complexity and severity levels. So as time changes, as the practice of law changes, we have internal teams whose sole job is managing legal relationships to ensure that we have, qualified, diligent, and responsible attorneys for our customers and our business, right? And so CNA likes to bring its experience in legal management relationships to the discussion surrounding selection of counsel. We will have recommendations depending on the jurisdiction, depending on experience, depending on the size of the claim. And we welcome your vetting of those attorneys. And then also if there's, sort of some insight that you might have as a customer, we want to ensure we understand why, and then receive sort of input on who you guys are recommending so that we can vet that relationship and come up with a solution together, depending on the claim.
Okay. That's good information to know. Okay, let's move on. So resolving the dispute, we've kind of outlined kind of the typical steps that we see. We've said, okay, there's usually some type of negotiation, and then we'll talk more about mediation, arbitration, or litigation as a dispute resolution. But tell us kind of what happens based on your experience during negotiation. What does that look like? Who's typically involved? And what does a successful negotiation look like? If you can touch on that, and based on some of the things that you've seen.
For sure, yeah, I love this conversation, how to resolve a dispute. And someday I want to lead a whole workshop sort of on dispute resolution, negotiation, philosophy, psychology, and strategy. It's important to, I think, appreciate that when a dispute is starting to bubble or it's fully escalated into a claim, whether it's litigated or not, you have to understand a little bit about the who, what, where, why, when, and how of a dispute. And understanding these vectors will help you define your objectives, but also, and I think more importantly, help you in resolving a dispute define the other side's objectives, right? So some common objectives in a dispute include money, project completion, timeliness, lack of performance, frustration in the process, hurt feelings, personalities. And in my experience, I'd say what may seem in the claim process as personal or hurtful is rarely based in downright nastiness or maleficence. I would say that most people have reasons, justifications, and they're valid on why they have a claim. And it's our job as claim professionals, it's our job as insureds in the process, as attorneys, to appreciate and understand why and try to bring some objectivity to it. I will say in direct negotiation that design professionals are really good negotiators. And if you think about it, you guys do it all the time. I mean, your whole life is effectively one big negotiation. You guys work through design changes and construction changes and owner-driven changes and site condition changes and pricing changes, scope and time and materials and change orders and just general disputes that come up on the project. And I think when we get into direct negotiations, maybe this resonates with everybody on the phone, is your typical mindset is, I got to get something I want. And I'm going to challenge that a little bit and offer a slightly nuanced mindset. That there's only really one thing that makes a negotiation successful. And the whole point of what that human exchange looks like is to find out what the other side wants or needs and how you can help them get it. And that's the brilliance of direct negotiation. That's the brilliance of being able to do something in the moment, is that you can help in the moment another human get what they need in exchange for value for you. So figuring out what their win is and then trying to get your win to connect with theirs and then just connecting the dots between, that's it. That's direct negotiation. So I'd say typically they start informally, right? You're walking on the job site, somebody says, we got to fix this. Okay, there's somebody's want. It doesn't necessarily have to rise to the level of, formal negotiations at a project meeting or a claim meeting. Oftentimes they do, right? Because there's got to be formality behind it. But when you start hearing stuff like that, it's good to start asking a lot of questions for a lot of reasons, right? You want to know who's involved, right? So asking the question about who are the decision makers? You want to ask why. What's needed for a successful negotiation of a particular issue? At this point in time, knowing the who and the what, it's probably a good idea to put us on notice, just because things might be starting to percolate up towards a claim if they're not already a claim. And it's good to have allies on your side to help you sort of brainstorm solutions, identify blind spots that you may not be aware of, and to get a sounding board. And you of course don't want to admit or bind anything without us being involved, but preparing for the what, doing your homework, understanding what options that they have, what needs and pressures that they have, who's involved, what will influence their needs, I would say are some good whats in understanding how you can get a win for them in exchange for value for you.
Okay.
The second part of it's communication, right? So, asking questions first and seeking to understand rather than seeking to respond creates what I would say is the third point, and that's trust. Listening and questioning builds trust. And to negotiate with someone successfully, you have to have a mutual trust in each other. And it's based upon, realistic positivity and a willingness to help and a willingness to listen and a willingness to empathize. And frankly, a willingness to incur some costs, whether that's money or effort, time, to help somebody else in exchange for value for you. And then when it is time to respond, it probably dictates a couple of things, right? It requires patience on your part, and that's not necessarily patience in time. It could be patience in listening. It could be patience in trying to strategically think out how a response is going to look. And then I always refer to the triple B's and the triple C's: being brief, brave, brilliant, clear, confident, and concise, and always relying on the why. Typically, if you were to negotiate using some of these sort of frameworks, you will find, some success in doing it. I think that you all have a personal style, and like I said, everybody has a lot of experience in negotiating, given the role that you guys have in your projects already. In the context of claims, it can be a very effective dispute resolution tool, and certainly we want to be involved with you and to work through you guys to help effectively resolve claims through direct negotiation. And you'd be surprised how often it successfully works.
Okay, that's a great synopsis. So let's move on then when we have other folks involved, right? So when does it make sense to start mediation? Kind of explain what the mediation process looks like, how they're selected, and so on. If you could just
Sure, yeah.
give it.
You're
Yeah.
probably all familiar with mediation and in contracts. We typically see when we're negotiating contracts, mediation being thrown around as a potential alternative dispute resolution. But for a definition, it's a negotiation where one person is in the middle acting as a facilitator. I like to call them a horse trader or a postal worker. They carry offers back and forth. We can ask them to evaluate. We can ask them to even to be a therapist for the other side, right? There's no wrong answers with what that person's role is. But effectively, we see mediation as a proper dispute method when we have multiple parties to a dispute, or when there's multiple issues, or when there's overly complex issues, or when relationships and trust have just soured to the point where direct negotiations can't occur. And so I'd say like mediation is favored as a dispute resolution because of a couple reasons. One, it's a voluntary process. It's not binding. Everybody has to agree to go to mediation, and everybody gets to decide whether the results at the end of the mediation make sense to them. They get to agree to them or not. Everybody must agree to resolve the case, and that means that the process of how we get there, the result, and the decisions are all within your control. And in an effort to make mediation fair and neutral, we typically decide together on who an appropriate mediator is. We share in the cost of the mediator, and we agree on the logistics of the location of the mediation, who is going to attend as decision makers at the mediation, and other sort of parameters like, what's really important, like who's going to, where are we going to get lunch from? Mediators don't need to be attorneys, but they typically are, given the fact that their job is usually resolving and managing disputes. Mediators are neutral. No one party at a mediation is going to be their client. They seek to resolve the claim. They seek to resolve the dispute. That's who their client is, the resolution of the dispute. And so you'll hear in mediation people leaning heavily about weaknesses in your case, and the mediator will be going to the other side doing the same thing because he wants the parties in a mediation to be working towards where his client is, and that's the negotiated resolution of the claim. I will say mediation is hugely beneficial and favored because it's so open, it's voluntary, and it's creative. So you can set a mediation for any amount of time that you want. It could be a half a morning, or it could be multiple days. It can span over multiple sessions. You can turn the mediator into a decision maker. You can ask for an evaluative proposal if you want. You can turn the mediator into an investigatory special master, somebody who can help the parties gather more information without running off to court and then reconvene at a later date to continue discussions. You can even ask the mediator to present a settlement proposal to a board of government individuals in government, or to a school board, to help insulate decision makers from that responsibility and prevent the future burden of making that decision. I mean, the options are endless with mediation, and that's why it's such a favored way to resolve disputes, and it's safe. Everything that's said within mediation, whether you decide to go sit with your client and have a kumbaya moment, whether you decide to apologize and say, I'm sorry that we're here having to have this discussion in mediation, it's all confidential. It cannot be used in court later on. Whereas if you're engaging in direct negotiations, you have to be a little bit careful, because that process could be used in the future as admission of liability. So mediation is definitely favored.
Great point. So let's move on now to some of these binding dispute resolution processes. Let's start with arbitration, what that process looks like, and then we'll go on to litigation.
Yeah, arbitration is the dreaded A word, right? Definitely not a favored method of resolving disputes. It does have, in some strategic instances, some benefits. That would be a very high-level evaluation and occur likely at the time you're entering into a contract for a project. But I would say, as a general sort of notion, that arbitration is disfavored in dispute resolution territory. Arbitration is effectively a private court system. It started typically by contract or agreement to use arbitration to resolve future disputes. And while there's factors that may try to make arbitration seem favorable over litigation, like less public scrutiny and confidentiality and perceived efficiencies and touted quicker resolution processes, it typically doesn't meet any of those once you get involved in it. I would say arbitrators, people who make those decisions around those panels, are typically attorneys that dedicate time away from private practice or mediation, and they charge you for their time they actually put into your case, and they charge you for the lost opportunity of your case for other cases they could be working on. What does that mean? That means you'll be charged for the time that they are working on your case, and they will charge you for the time that they dedicate to your case, even if it gets settled or dismissed or continued because you can't meet the deadlines. And so it's an expensive proposition to go into arbitration. Most arbitrators work for large groups like that are around the country dedicated to arbitration and mediation. And so they have a business footprint that they need to support. And so there's also costs that are associated with the process and overhead associated with that. Arbitrations can be challenging because they're not always based in the law. The decisions aren't always based in the law. And what does that mean? They have to follow the law, but oftentimes the process is sort of open-ended, meaning that motions are typically denied. So if you think you have a good motion and the law would not support the claim being made against you, an arbitrator would typically not just gut somebody's case and kick them out. They also let almost all evidence in during the actual arbitration process, and they'll evaluate the evidence not based upon the rules of evidence necessary, what's admissible and what's not, but based upon how they feel like the evidence stacks up to the actual result that they want to get to. And so when we say it's not always based on the law, it doesn't have the same legal scrutiny that the court system provides for what's admissible as evidence, what claims can survive motion practice, what claims can be brought, what claims don't need to be brought. And so you can find some unfairness in the process. And we've had experience with that. We've had experience with claims that we've arbitrated to a decision where we felt like we should have won them because we had admissions by the owner claimant making the claim. We've had witnesses come in and testify so favorably, but it just wasn't read that way by the arbitrators. And so you're stuck with a decision oftentimes that you may or may not agree with, and you say, okay, well, I don't agree with this decision. What right do I have to do anything with it? If you're in the court system, you can appeal it. If you're in the arbitration system, you really can't, unless it's very, very, I'm gonna read the standard here because I find it fascinating. The only right of appeal you have is either one, to the same group that made the decision, at which case you're gonna have a whole new case number, a whole new group of arbitrators, a whole new cost and fee structure for that. So that in and of itself is expensive. Or you can appeal it to the court system, and they have to file something called the Federal Arbitration Act, which provides reasons why an award could be vacated, like thrown out or modified. And to give you some sort of insight in what that looks like, it would be vacated or thrown out if there's corruption, fraud, undue means, criminal conduct, or misbehavior by the parties of the arbitrators. That's the highest. That's probably one of the highest standards you could ever have to meet. It would be changed or modified if there's evident material miscalculation, in quotes, or to modify or correct the award so as to affect the intent thereof and promote justice between the parties. I don't even know what that means, right? You could argue that all day long and it's never going to get overturned. I guess the point is that there really is no right of appeal on an arbitration decision, and so you're sort of stuck with it.
Okay. So let's move on then to the big one, the other dispute resolution mechanism, which is litigation. And kind of walk us through the typical steps of litigation and what that looks like.
Sure, yeah. Litigation isn't as, I would say, because we play in the arena often, it's not as scary as it sometimes can be. And there are people, there are owners, there are, design professionals, there are contractors that strategically use litigation. And oftentimes there are strategic reasons to use litigation. We could jump into that in a future program. at some point, or if you have any questions, you feel free to reach out to me and we could talk it through. But litigation typically gets started the same way any claim does, right? There's usually you can't agree in direct negotiation, or you've been to mediation and there's been an impasse as to, who thinks who's responsible and who's doing what on the back end. And so, somebody says, I'm gonna have to file a suit. That could be out of necessity because of time limitations. It could be because of the need or desire to move the dispute or the claim forward. But typically, and you could initiate it, right? Let's assume you take your client to court because you're not getting paid. And that means you sue your client for money. You should definitely let us know that you're contemplating doing that so we could talk through it. But that could be one way that a complaint is filed. You could start when your client decides that the design firm or a subconsultant under a design firm isn't doing what they should do, and so they sue you for a wrongful act. Definitely let us know, because that's a claim, and you let us know so we can jump in and assist you with that. And then it could also start where a contractor is having issues on the project, and they start to blame the design firm for delays or increased costs or other problems that they're having on the project. And so that means that the contractor either files suit directly against the design firm, or they file a complaint against the plaintiff or the owner, and the owner decides who else should be involved in that litigation. And so the chart that we have flashed up on the screen right now can show you all the different maturations of what litigation can look like. It starts when somebody files suit against somebody else, and then everybody else involved in that claim gets involved with it. They can get involved with it either through a direct complaint, plaintiff is suing defendant. They can get involved with it because of a third party complaint. So the defendant looks around and says, I think there's other people that should be involved in this. And so they file their own complaint against others. So that would be a third party complaint. They can get involved with it because of a counterclaim or a cross claim, where the defendant here, the contractor, looks back at the plaintiff and says, you know what, you're responsible for this, not me. And so they file their own cross claim against the plaintiff. Or one of the third party defendants says, I don't think I'm responsible for this, so I'm filing a counterclaim against everybody else. And so you can see how in the context of business, it can get very complicated quickly. But when you look at the flow chart of how things work out, it's pretty clear. I would say, yeah.
I'm sorry. Go ahead and finish your thought. I apologize.
No, I would just say that, there's some things to be aware of, right? And so I don't know if this is on the next slide, Nahom. I can't remember. No, we're not there yet. But I was going to say that there's some things to be aware of, right? In litigation, right? So it often happens where litigation is filed and we're not a party to it. So let's say the owner, contractor are fighting with each other. They go to litigation, and we're just sitting off to the side. That's a red flag. Why aren't we involved? I mean, there could be good reasons why we're not involved. It's a contractor performance issue. The surety's getting involved. They needed to trigger their bond, whatever the case may be. But that's a red flag issue, asking sort of why aren't we involved and could we be involved? Another red flag could be where you're asked to sign a tolling agreement, right? So there's litigation that's pending between two parties and it's not pending against you, but somebody comes and says, I don't know if you should be involved with this, but I want to reserve my rights to and not have them waived, and I don't want you to get involved with this, so we're going to have you sign this tolling agreement. When that stuff starts to happen, definitely give us notice. That's what we want to know: tolling agreements and when litigation's brought on a project that you might not be involved with. And then I'd also check and make sure your fees are up to date. Are you getting paid? Is your accounts receivable, in arrears, or is it up to date? Just making sure that some of those red flags are being looked after will help when you're evaluating strategy and litigation.
Okay, so let's move on. Oftentimes your contracts do have obligations that relate to dispute resolution mechanisms. Oftentimes, even if litigation is selected, there are things that say, okay, should we have a judge or jury decide? oftentimes in commercial relationships, my experience from reviewing contracts is that jury trials are not often selected, and that's usually a bench trial. Nick, could you briefly touch on that, and then we'll talk about prevailing party clauses as well?
Yeah, so judge versus jury is a real important sort of decision on how a litigation gets resolved, because you're effectively deciding who your decision maker is. And Nahome's right. I mean, oftentimes we do see a judge acting as the decision maker in technical cases involving architects or engineers. But I think that analysis really does come down to the nature of the case and the jurisdiction. Oftentimes, judges are elected, they're not appointed, and then you have to look behind the scenes about how are they getting their money for their campaigns when it's up for election, right? And so all that stuff is public knowledge. Typically, we see a lot of attorneys that are donating to the judiciary election campaigns. And then, of course, the type of case, bodily injury or technical. Jury, on the other hand, is a group of peers. I'll put that in air quotes, 6, 8, 10, or 12 people who decide the case. And there's often perceptions with jurors that they don't care, they don't understand. I would say in my experience that jurors make the right decision if the right story is told. They typically find parties that act correctly and side with them. I would say we get a fair shake with a jury, but those are some of the factors to determine whether you are involved with a judge or a jury.
Okay, great points. And I just want to reiterate, at the end of the day, most claims with CNA are settled or negotiated out. Very rarely do we go to a judge or jury or arbitration. So, over 95% of all claims are typically settled out. So these are rare events, but when they do happen, they can be very nerve-wracking for firms. Obviously, there's some uncertainty. So, we just wanted to highlight some of these issues. The other issue that comes up in contracts are prevailing party clauses. And what this means is that the language says that if there's a dispute, the prevailing party gets to collect their attorney fees. And from a coverage standpoint, from your insurance policy, that's a contractually assumed obligation. In the United States, typically each party pays for their own attorney fees. But if by contract you're shifting these agreements, then that's a contractually assumed obligation. And so the guidance that we provide in risk management and from your counsel is that you make it clear that each party pays for their own attorney fees. And then the last point, when you're looking at contracts, is consistency in sub-consulting agreements. And Nick, if you could touch on that and see how, give them, examples of where that could lead to issues, and then we'll move on to the next.
Yeah. Just real quickly, right? So consistency in sub-consulting agreement refers to, the interplay between litigation as a dispute resolution mechanism and arbitration. So if you're, as an example, if you have an owner that, is requiring arbitration, you want to do the project, you can't get out of it, and you sign it up, you better be sure that your sub-consultants contracts match the prime contract so that they have arbitration as a dispute resolution. We get involved, unfortunately, in situations where those sub-consulting agreements don't call for arbitration, and at that point you can be stuck holding the bag for your sub-consultants in the arbitration, only to have to turn around and sue your sub-consultants to recover in contribution afterwards. It's a challenging situation to be in. So taking the time to be consistent in the agreements is a really important piece of risk management.
So Nick, you've provided us great information. If you can just kind of briefly go through some of the steps that are required that go through for the litigation process.
Sure.
Start with discovery.
Yeah, and if anybody wants to dive deeper into this, feel free to reach out to Nahome or I. I'm going to go really quickly through it, but effectively litigation is like a wave. And you start off the wave with the filing of a complaint. you're sitting in your surfboard, you're looking out towards the horizon, and you're seeing a wave start to develop, you're seeing a crest start to develop, and that's sort of the filing of the complaint. And once that's filed, you'll get into preliminary motions to dismiss. Does that complaint state a cause of action that they can recover? I would say the courts are typically in favor of yes, they are. It's hard to get out on our preliminary motion to dismiss. And once that is decided, you go into discovery, and there's two prongs of discovery. The first one's written discovery, where you have to provide your documents and answers to written questions. Those are interrogatories and requests for production. So you'll have to provide your documents, and then an attorney will review your documents for confidentiality and proprietariness and attorney-client privilege and the like, but they will be produced. And after written discovery, you go into depositions, and that's where people sit down and answer questions. I will say that this part of the process is the most expensive, and it's also the most important. Cases are won or lost based upon discovery, and so it is necessary to be involved, it's necessary to be informed, and it's necessary to take the time to do it right. Plaintiffs' attorneys look for opportunities in discovery to win their cases and set them up to resolve. So a very important part of the process. Afterwards, we typically get into expert disclosures. A case cannot be brought or maintained without an expert disclosure typically, and that means that somebody has to come in and say that a design professional did not act in accordance with what the standards are in this community at this time. And the reason why an expert is necessary is because what you guys do is typically outside of the purview of a layperson that requires somebody to come and say, yes, they did something wrong. That is, usually you have a picture of, a street corner in some big city where, they can go out and find anybody they want to make those opinions. I'll just say that, money can buy what they want people to say. And so typically it's not an issue for them to find somebody to criticize it. And finally, after expert disclosures, you can get into some additional motion practice. Like after all the facts have come in, is there a claim that exists? Or is there a material fact that a decision maker, like a judge or a jury, would have to weigh? And if the answer is yes, there is a material fact, you have two options. You settle the claim or you try the case. And those are the last part of the wave that comes after the wave crests over. Motions to dismiss are denied. Case can't be settled, the wave crests, and it goes to trial. And after trial, after a verdict or a decision is rendered, the wave disappears and washes up on shore. So that's the analogy we like to use.
Great analogy. So once a claim has been made, great, do report immediately. That is an affirmative obligation that you have under the policy, and you are indeed required to report and do that immediately. And then, Nick has touched on this, but we just want to reiterate, right? Do not admit liability. Do not sign or agree to anything before speaking with a claims specialist. Do not attend meetings with opposing parties before speaking with CMA, and do not destroy any records. So, Nick, if you could just sum up this issue, the slide here.
Yeah, I mean, I think it sort of speaks for itself, but it's the typical stuff that you would find in your policy, making sure we're not admitting anything or signing anything or doing anything without speaking with us. The policies that we have are practice policies or consent policies, and it's important because that means that we can't run off and do anything, settle a claim without your consent, and vice versa. We want to make sure that we're working as a team and going through it together. We also want to make sure that for your business processes that we have good document retention policies, that we're not destroying any records, meaning that we're following what our policies say. And if you get a litigation hold, like somebody writes to you and says, you need to hold on to all documents related to this project, that you turn that into us first of all, so that we can help you implement a good litigation hold on those documents related to that project. That's one of those red flags. And then, of course, the last one, traditional and social media. If anybody's reaching out to you to ask questions from the traditional media source, or there's people posting on social media about the project or about your role or anybody internally, just be wary that that stuff is usually a red flag for additional claim activity or litigation that could be ensued.
So how to prevent a claim? Obviously, your contracts are first line of defense. Your contracts not only describe your scope of services, it often lays out the communications protocol between you and your client, how you're supposed to deal with the contractor's requests on a design bid build. So the communication protocols are there, who has the authority to make decisions. All of these things are laid out in your contract. So contract negotiation oftentimes sets expectations between you and your client. You get a sense of where they're coming from, what their thought process is, and how well they're managing projects. So contracts are oftentimes your first line of defense. And then there's obviously some basic risk management practices, right? Nick has alluded to this, but your ability to document what has happened on your project and how well you can produce those documents oftentimes can be a key issue when you're defending against a claim. Record retention is obviously important. Most firms have formal record retention policies in place, how long you keep them for. That's important so that you have the ability to produce records in the event that a claim happens. Oftentimes, a claim may happen after the project is done, after substantial completion, so it's important that you be able to produce what happened when a claim comes in. QA, QC procedures are obviously are important, making sure that the documents that go out on your behalf have been reviewed and meet the quality requirements that you all have. And then finally, what we want to emphasize is staff education, right? Project managers by nature tend to want to solve projects. It's important that if there is a problem, if something doesn't feel right, that people feel comfortable coming to you as leaders or raising the issue internally that there may be a problem, so that you can tap into the resources that Nick highlighted, whether it be a circumstance or something to bounce off of others. Just be aware that if something doesn't smell right, that it's probably better to say something about it and make sure that you are tapping into the resources that are available to you. From what we have seen, we look at contracts as the first line of defense, and this is just a chart to illustrate for the claims that were reported between 2013 and 2022, what the percentage of claims looks like. About 5.3% of all claims in this period related to oral contracts, and we see that as something that really presents challenges. I think over the years, the number of claims that relate to oral contracts have gone down. So that's kudos to the community for improving on that. But that's something that you want to be able to document your agreement, have it executed, and to that end, we have some incentives designed to encourage these good practices. The policy has two items, a risk mitigation credit and an early resolution credit. For eligible policyholders, there's a reduction of the deductible obligation by 50% up to $25,000. And if certain steps are taken, then CMA will forgive a portion of the deductible. And you must apply for the credit and supply supporting documentation when the claim is reported. And what that looks like is, as I alluded to earlier, is that the most important thing that is a baseline requirement is that you have an executed professional services agreement. So what do we mean by executed? This is not just an indication that contracts were exchanged. We actually require that you have a signed professional services agreement in place laying out what it is that you all promised between each other, you all being the client and you, the design firm. And then 3 of these 6 conditions have to be made, that there are payment terms and invoicing procedures in agreement, That's important because, as Nick alluded to earlier, one of the issues that often comes up is that there are payment issues that haven't been resolved, and you, in your efforts to recover payment, may file a claim. That often leads to a counterclaim against you that you were negligent. So if you have your payment terms outlined and it's clear and you are current on these things, then oftentimes the payment issue doesn't enter into a dispute, doesn't complicate it. So, that's one of the things that the risk mitigation credit tries to promote. The other is the interprofessional agreements and insurance certificates. If you have sub-consultants, have executed agreements in place, pre-project planning with the client, peer review, constructability, and submittal management processes and records. So to get that risk mitigation credit, you need 3 of these 6 conditions that are outlined, and this is all in the base policy. The other incentive that we have is the early resolution credit. You can have one, either the risk mitigation credit or the early resolution credit. And if there's early resolution of a claim within 180 days of you reporting a claim and it's resolved by negotiation or mediation, then there is an incentive for that early resolution, because it's not just about the money that is paid out, but it is also the time element that reduces your exposure as well. So those are the 2 features that are available in your policy to encourage settlement and to encourage good practices. And then finally, Nick, we've gone a little bit over, but if you can talk about the leadership team at CNA.
Yeah, sure. And I know I'm cognizant of the time. I appreciate you guys sticking out with us. Last slide, sort of our leadership team at CNA. If you want to take a snapshot, or I think these might have been provided. This is just a place for you to come if you have any questions or you have any concerns about a pre-claim or a claim that may have been reported into, or you just want some information, or you want to offer some feedback. We want to open that up to you guys as our customers, our policyholders, our partners, to ensure that we are there for you. So Anthony Jones is our Assistant Vice President, responsible for the program. Myself, Nick Lopazinski, and Peter Preston are 2 directors on the team that run the team with Anthony. So this is the last slide. Our information's on there. Feel free, never hesitate to reach out.
Okay, and there's a lot to be said about the CNA claims team. I think they're exemplary, provide great service for our clients, a great geographic spread, a lot of experience. We're running out of time, but there's a lot to be said about the claims team, and it's always a pleasure to work with you all. Thank you, Nick, for taking the time to present for our clients. This is a great presentation. And thank you all for attending. Look for the survey and your downloadable certificate, and we will get that taken care of for you. A couple of things that we want to talk about is our resources that are available to all policyholders. There's the new contract sifter. There's the continuing year education platform. All of these resources are available to you. Please, if you're not already registered on our website, make sure that you take advantage of these resources. And then finally, we do have another webinar coming up on Wednesday, July 12th, Construction Phase Risk Management. Be sure to sign up when those notices come out, and we really appreciate your attendance. Thank you all, and have a great day.